Good evening, everyone. My name is Carla McKanders. I am a professor in the law school where I direct an immigration clinic. And so my students, during their second and third year of law school, can practice under the supervision of a professor and an attorney. And so what I do is, what I'll talk about here is humanitarian immigration cases with my students. We also have one of our student undergrad volunteers here, Sandra, who interprets for our students, law students who are in the clinic. So today I'm going to talk to you about deferred action for childhood arrivals. I'm going to give you a little bit of Immigration 101 to give you some context about the different concepts that we'll be talking about for DACA. I'm going to talk about immigration in Tennessee, why it's important to kind of understand basic immigration law concepts. And then we'll go into talking about deferred action, what are the requirements that need to be met in order to apply for deferred action for childhood arrivals. So I'm going to try to get some audience participation. So as a professor, I have to do that. So when we talk about immigration law, the source of immigration law comes from the Constitution. The Constitution provides that Congress shall create a uniform rule of naturalization. And that means that Congress has the authority to pass the Immigration and Nationality Act. The Immigration and Nationality Act is really, really complex. When I'm working with my students and teaching them how to navigate through the immigration code, you have to cross-reference different sections. It's second in complexity to the tax code. So if you can imagine, it's very complicated to navigate. You also, in addition to the Immigration and Nationality Act, there's the Code of Federal Regulations. That also provides like guidance and guidelines for navigating through and practicing immigration law. And then in addition, the different departments that work with immigration and the regulations issue policy memorandums, they issue statements, they issue frequently asked questions to help people navigate through the Immigration and Nationality Act. So if you can imagine, as an immigration attorney, you have to navigate through all of these different complex pieces in order to assist people in immigration law. So the organizational structure of the immigration system can be kind of complicated. This is the most complicated piece when I'm working with my students and explaining who they are going to be interacting with over the course of the semester in doing immigration work. So in general, we know that there are how many branches of government in the United States? There are 3. And what are those branches? Legislative, judicial, and executive. So the immigration piece works with the executive branch. And what are the components of the executive branch? The president. And who works underneath the president? Cabinets. And who is in the cabinets? What are the different cabinet members? Secretary of Education, Treasury, Homeland Security. So the 2 departments that work with immigration are the Department of Homeland Security and the Department of Justice. Prior to 9/11, these 2 functions used to be under the Immigration and Naturalization Services. After 9/11, you had the creation of the Department of Homeland Security. And so the Department of Homeland Security processes immigration applications through United States Citizenship and Immigration Services. And then you have 2 different divisions that are in control of interior enforcement of immigration laws, which is the Customs and Border Protection, affectionately known as ICE. And then the Customs and Border Protection are the guys that, women and men, that are in the airports at our borders that are interviewing you when you come in? How many of you have traveled through the airport internationally and come back and have been questioned by Customs and Border Protection? So those are people or individuals who are under the Department of Homeland Security. The Department of Justice, underneath there's the Executive Office of Immigration Review, and that's where the immigration court system is. And so we are in Knoxville, and Tennessee is jurisdiction for the Memphis Immigration Court. And so if you're placed in deportation or removal proceedings, you would go to the Memphis court. If you want to appeal a decision of the immigration court, then you'll go to the Board of Immigration Appeals. And so when we're talking about DACA, you are going to file your application with the Department of Homeland Security, and you're going to be with USCIS, United States Citizenship and Immigration Services. So I want to ask you a question. How many people are aware of the different types of immigration status you can have? And what are some of those? Lawful permanent resident. So employment, so you could have like a visa. What other status, different types of immigration status can you have? You can acquire status through marriage. What's the one that if you have lawful status, the opposite of lawful status can be undocumented status? And then what's the one that it's probably too obvious to? U.S. citizen. So there are 4 different types of immigration status, and with each status, you obtain certain rights. So the first status that you can have is a U.S. citizen. And as a U.S. citizen, you can be born as a U.S. citizen through a concept called jus soli, or you can acquire citizenship through your parents by jus sanguine. And so as a U.S. citizen, you have the right to work, you have the right to vote, you have the right to certain benefits, and you cannot be removed from the United States. The second category that we have are lawful permanent residents. And a lawful permanent resident is an individual who is in the United States. They can obtain certain benefits. They cannot vote in the United States, but they can work here. With lawful permanent resident status or a green card status, if you're convicted of certain crimes, you can still be removed from the country. Or if you commit certain acts, you can be deemed inadmissible. The next category, and you can, after 5 years, or depending how you got to the lawful permanent residence category, you can adjust your status to become a United States citizen. The other category are temporary visitors. And so temporary visitors are known under the Immigration and Nationality Act as the alphabet soup of immigration. So if you come to the United States on a visa, it's a temporary status. So you can come on a student visa, you can come on a tourist visa, you can come on an employment visa. And so that status, as when you hold a visa, will expire at some period of time. And it does not necessarily lead to lawful permanent resident status. It depends on which visa category you hold. And certain visas give you the ability to work in the United States, and if you have a student visa, you can have restricted ability to work in the United States. And then the last category are undocumented immigrants, and that's someone who doesn't have the permission to work or live in the United States and can be subject to removal or deportation. One thing to remember is that you can go from being a lawful permanent or a temporary visitor to undocumented status. You can also go from lawful permanent resident status. If you stay out of the country for 6 or more months, you can, be undocumented. So these categories are you can switch from one to the other. Another thing to be aware of is that as a lawful permanent resident or an undocumented immigrant, you can intend to remain in the country on a more permanent basis, or an undocumented immigrant or someone who is in the visitor status or visa status could intend to stay here for a temporary period of time. See, it's not advancing forward for some reason. Okay, here we go. So these are just some documents too that you may have seen. If somebody has a visa, they'll usually have in their passport this example. It's from an old textbook or case law book, but this is an example of a visa that you might see. And this is an example of a lawful permanent resident card or a green card. So in understanding immigration law, there are three primary ways to come to the United States or to migrate to the United States. There are family-based immigration, employment-based immigration, and humanitarian-based immigration. For family-based immigration, just in general, if you're married to a U.S. citizen or lawful permanent resident, you can come to the United States. If you're a spouse or children of lawful permanent residents, you can come to the United States. So, and there are different time frames depending on which category you fall in. Employment-based immigration is based upon a profession or skill, and these are just some of the different categories that will give you the ability to migrate to the United States based upon your employment status. This is my favorite area because this is the area that I practice in with my students, is humanitarian-based immigration. And so the most popular one that people know of are asylum seekers or refugees, and those are people that fear returning to their country of origin because they've been persecuted or will be persecuted. U visas are for victims of violence who help with the investigation or prosecution of a crime. Special immigrant juvenile status is for children who are under the age of 21 who have been abused, abandoned, or neglected by both parents. T visa, trafficking visa, and then the Violence Against Women Act protects victims of domestic violence by a spouse of a U.S. citizen or lawful permanent resident. So that gives you an overview, a very quick overview of the immigration system. Now I want to talk about why immigration is important to Tennessee. Tennessee has had a great increase in immigrant populations. The number was, I think it was a 200% increase in immigrants coming to Tennessee over the last 2 years or last 10 years. And then I think the number has dropped, but it's still high. It's like a 94% increase of immigrant populations. And when I say immigrant, that includes the full spectrum, all of the categories that we went through. This map shows us that Tennessee is one of the states with a 200% or higher growth in immigrants across the country. And as you see here, Florida, Texas, California, our Northeast states are on here, but most people wouldn't expect Tennessee to be on this map. But Tennessee has had a substantial growth in immigrants in the last 10 years. Mm-hmm. Well, when you look at the breakdown and the numbers, you see that a lot of people are migrating to Nashville. A lot of people, I know Carlos, I had a chart, but I thought you might be using it, and it shows the migration patterns in East Tennessee. A lot of jobs here. We have a substantial Latino population that lives in Gatlinburg, Morristown, that works in I think there's a cat or cage factory in Morristown. In Chattanooga, when I first started teaching at Tennessee, there's a Pilgrim's Pride poultry plant. So, and then with the increase of unaccompanied minors, children are joining their parents. So over, I think, 2014, we had an influx of children coming to Tennessee to be reunified with their parents who have been here for a while. No problem. So deferred action for childhood arrivals. In on June 15th of 2012, the Secretary of the Department of Homeland Security, so if we go back to the executive branch of the government, you have the different departments, and then you have a secretary, the Secretary of State for the Department of State, and for the Department of Homeland Security in 2012, you had Janet Napolitano, who was the secretary. And so as the Secretary of the Department of Homeland Security, they issue, the Immigrations and Customs Enforcement, they issue the notices to remove someone, so they act as a prosecutor to remove individuals from the United States. And so, as generally we know, if we apply concepts of criminal law, the prosecutor has discretion to execute or to prosecute somebody for a crime. So the Secretary of Homeland Security has that same authority to say who should be removed from the United States. Once they make that decision, they issue what's called a notice to appear, or the civil complaint that brings the allegations stating that this individual is removable from the United States. So in that context, the Secretary of Homeland Security stated in 2012 that we are going to exercise prosecutorial discretion, and for certain individuals who meet specific criteria, and we're not going to go after them to try to remove them from the U.S. And so this can be kind of confusing, because when DACA first came into existence, people thought it was an executive order by the president, but it's not a statute, it's not a regulation, it's not an executive order. It's the Secretary of Homeland Security exercising prosecutorial discretion. So deferred action, it's a ongoing policy. So when I go to court in Memphis with my students, you have a sub group, the Office of Chief Counsel with Immigration and Customs Enforcement, and on an individual basis, they will make decisions about whether an individual, they should move forward with trying to remove them from the country. And so in our practice with the immigration clinic, we've had individuals who have had a debilitating illness, who have been in the country. We have had parents who are taking care of kids who have illnesses, and then ICE, the attorneys, will decide not to move forward with that case because there are certain circumstances that don't warrant going forward with the removal of that individual. So deferred action, the agency, the Department of Homeland Security, determines that the person is not a priority to remove from the country. And so the benefits of deferred action are temporary relief from being removed from the United States. You get a work authorization card, and it's valid for 2 years. And during that period, you will not be removed from the United States. And you can travel outside of the United States, but you have to fill out another application for advanced parole through USCIS. The drawbacks are that it's temporary. You have to renew it every 2 years. It does not give you an immigration status. So those different categories that we looked at up here, this does not fall within any of those, a visa or lead to lawful permanent resident status. And then it doesn't cure unlawful presence. So if you accrue unlawful presence in the United States, there are certain provisions. So for example, if you married a US citizen, you wouldn't be able to adjust your status immediately to a lawful permanent resident because you've accrued unlawful presence. And then another drawback is that you're now putting yourself into the system, and the Department of Homeland Security knows that you're in the United States and you're undocumented or unauthorized. So in law, what we do is we take a statute and we divide it into elements. And the elements are the criteria that you have to meet to get the benefit. And so the DACA qualifications are: you have to be under the age of 31, as of June 15th, 2012, that's when DACA was announced, you had to come to the United States before reaching your 16th birthday. You have to continuously have resided in the United States since June 15th, 2007, up to the present date. You have to be physically present in the United States on June 15th, 2012, and at the time that you're making your request for a deferred action. You had to have had no lawful status, so you're not going to fall under the lawful permanent resident status or the visa status as of June 15, 2012. You're going to have to fall in that undocumented category that we showed. You have to be currently in school, working to obtain your GED, high school diploma, or you have to be a veteran or in the Coast Guard or Armed Forces of the United States. And then one of the complicated areas is you cannot have committed a felony, significant misdemeanor, which is defined under the law, 3 or more misdemeanors, or pose a threat to national security or public safety. And this one is kind of tricky because we had a case in the clinic where one of our clients was in the United States since he was 2 years old, got in trouble with the law. None of his charges were, they were all dismissed. He was still referred to immigration, and there was an allegation that he was involved in a gang, just an allegation. And based upon that allegation, he was not able or not eligible for deferred action. So right now I'm going to go through these categories that I've talked about. So first, the most complicated thing about DACA is collecting all of the evidence to show that you meet all of the criteria. And so the age limitation, usually you will have a birth certificate, and that birth certificate will show that you're under the age of 31 or you came into the country before the age of 16. We've worked with our clients to work with the consulates and embassies in Atlanta so that we can obtain birth certificates if the individual doesn't have a birth certificate. This should say 2 through 4 physical presence. Coming to the U.S. before your 16th birthday, these are just some examples of documents that you would have to have in order to show that you were in the United States before you were 16. It's easier for individuals who were enrolled in school before their 16th birthday, but we've had clients who were not enrolled in school, were working, but don't have any record of it. So you have to get kind of creative in terms of trying to prove your physical presence. And then you have to prove your physical presence on June 15, 2012, which requires a lot, because I don't know if you guys have any documentation that you were in the United States unless you keep all of your receipts and everything on that specific date. So it can be kind of hard to prove, and continuously resided in the United States since June 15, 2007. And so as an attorney, what we do is we go from June 15, 2007 to the present day, and we go quarterly, and we obtain documents from each quarter so that we can show that the person was in the United States. And if you can think back, like how many years and quarterly, it's a big task to compile all of these documents. And most of the individuals that we've done applications for, it falls under mortgages, tax receipts, insurance policies, medical reports, and not the one where you have like the passport stamp, because a lot of people don't have that stamp. The physical presence, there is an exception that you can have an interruption in your presence in the United States, but that interruption has to be brief, casual, or innocent. So this particular element just means that you could have gone back to Mexico for the death of a family member, then you came back, and you can't have been removed from the country through deportation and then come back to the United States, or have taken what's called voluntary departure. That's if you're in removal proceedings and you voluntarily agree to leave the country, and you did not leave the country when you told the court that you would. Out of status, this just means that you did not have status at the time. Status means that you're in this undocumented category that was on the board. If you were placed in removal proceedings and you didn't show up for your removal proceedings, you'll have an in absentia order of removal. Those individuals can still apply for deferred action. The education requirement, a lot of my younger clients were in school, have graduated from school, are able to meet this element. My older clients are working to obtain their high school degree or their GED, and that's why I have a star there, because you also can be in a program that leads to your obtaining a high school degree. So if I've had clients who are taking English classes that are leading to them being able to obtain their GED, or honorably discharged from the U.S. Army, Armed Forces, or Coast Guard. Criminal activity, if someone falls in this category, we recommend that they obtain an attorney to help them. Felony is kind of straightforward. It's if you've had a federal or state felony, you're excluded. 3 or more misdemeanors, you're excluded. Again, the generalized concern of public safety and national security can exclude you. And then significant misdemeanors is defined by federal law, but if it's an offense that falls within one of these categories, that would constitute a significant misdemeanor, or if the sentence is for more than 90 days, it would fall into the significant misdemeanor category. And then what we have to watch out for, the Tennessee, just across the state, they're doing expungement clinics to wipe people's records clear. And for immigrants, you don't want to wipe your record clear because it can expunge convictions, can still be a basis for denial of your application. So you want to keep the record there so you can show whether what you were charged with, whether it was dismissed or not, falls within one of these categories. So this is just the USCIS website. It's where you'll find all of the forms that for different forms of immigration relief, applications for citizenship. This is where you'll find the Deferred Action for Childhood Arrivals application. You have to fill out the application, the work authorization form, the instructions, and then you have to do like a worksheet to show why you're eligible or need work authorization. And that's just the website where you can find it, uscis.gov. I always tell my students that behind every question on an immigration form, there is a legal issue. So when you're going through the DACA form, you need to be cognizant that when a question is being asked, it's assessing the criteria that we just went through. And so I always recommend that if you have a question, you probably should get an attorney to help you fill out the form. And then one really important thing, any immigration forms that you fill out, there's a section at the bottom right before you sign that says that false statements can be prosecuted, and then it can affect your ability to obtain immigration relief in the future if you make false statements. So the filing fee is the fee for the application is $380, and then there's a biometrics portion to the application for $85, and you'll have to go get your fingerprints taken to process your application. This is just an overview from USCIS of the process. What is the most labor-intensive part, especially if you weren't enrolled in school, are collecting all of that evidence and putting that together. Some attorneys will require that you assemble that first, all of that information before you come to them. So once you have the evidence assembled, then you'll complete the forms, you'll mail it in, you'll get your biometrics appointment, and then you can continuously check the status of your application on uscis.gov. This is just to remind you that deferred action falls in this category where it's not a path to immigration status and it's not a permanent status. Again, it's just prosecutorial discretion. This gives us some of the statistics on the amount of individuals who have applied for deferred action and have been approved for deferred action. And as you can see there in the cumulative total of initial applications is about 770,000, and then the renewal application. So after the 2-year expiration, you have to reapply for DACA again, is about 435,000. This gives you an idea of the different countries from across the United States of individuals who have applied for deferred action for childhood arrivals. We see Mexico, El Salvador, Guatemala, Honduras, then South Korea, Ecuador, Philippines, India, Costa Rica, Pakistan. So you see there is a diverse group of individuals who are applying for deferred action. And this just shows us in Tennessee the amount of individuals in 2015 who have been who've been accepted, and it's around 8,000. The renewals are around 4,000 in Tennessee, and it gives us the number total 10,000 that have been approved to date. So to end, we all know that it was last year that President Obama said that there was a new program with deferred action for childhood arrivals and deferred action for parental arrivals. The DACA was just an expansion on the previously existing, the program that I've just described, and DAPA was to, if you have a son or daughter who is a U.S. citizen or lawful permanent resident, you would be able to apply under this new category. But these updates are on hold because there's federal court litigation and an injunction, so DAPA and DACA cannot go forward. So that's the end of my presentation, and I think we'll take questions at the end.